my people, a lot is really good in the political zone. As today marks the day of the tribunal judgment, this is the day that all Nigerians have really been expecting, and today have finally come. Bola Ahmed Tinubu, Peter Obi, and Atiku, they're presently in court right now, and the tribunal are about to pass their judgment. So the lawyer Peter Obi have finally come out to see a particular thing, he rule out a particular thing that makes the judge to side Peter Obi in this very moment. Tinubu is in serious trouble at the moment because what Peter Obi lawyer said is very tragic, and this is making Peter Obi to be winning in the tribunal at the moment. So I'm going to show you the video now of how everything is going and what Peter Obi lawyer said, things that he said in course of his statement during the ruling. We'll then stay connected. Peter Obi is winning at the moment. I'm coming back again.
Welcome you back to LAJUPOG TV.
I don't have bad news for you today.
The home of religious gossip.
But you should leave the fight for Mohammed.
What is happening in the Christendom? Joinder, it makes sense with LAJUPOG.
Hello my great and wonderful viewers, welcome back to LAJUPOG TV. For those of you coming across this channel for the very first time, ensure you click the red subscription button appear on your video screen, and do well to click the notification bell icon so that whenever we drop a new video in first time, YouTube will easily notify you. It is ongoing in the tribunal right now. We are in tribunal live, and that is where we are at the moment. Peter Obi is in court, Tinubu have run out of Nigeria, Atiku is presently in court as Tinubu is in India. You know, the ruling on the tribunal is ongoing at the moment. Peter Obi lawyer is really defending the obedient mandate at the moment, and what Peter Obi lawyer said in this video in course of this ruling in court today shocked everybody in the tribunal, and that makes the judge to give a positive vibe for the obedience. The judges on seat, they are already inside of Peter Obi because the tragic things that Peter Obi lawyer said in the court today is ongoing live, and I will leave you guys to watch the video in the court at the moment. You will see the video yourself. I just want to give you a little recap regarding what is going on. Peter Obi lawyer have finally shocked Tinubu in a place that Tinubu cannot even imagine. Tinubu lawyers thought they are very smart, but Peter Obi lawyer have finally outsmart all their things that they're doing in the court for the past few days. You know, in course of the election, it's normally known that there were voters intimidation, voter suppression, and all of that. When Peter Obi went to the court, the moment they announced the number of the president-elect and later inaugurated president of Nigeria, the court demanded for 50 evidences from him, but he was able to tender 13. That is where the whole issue started from. He was able to tender 13 out of the 50 evidences, but Peter Obi said he was okay with it because he tendered the most important evidences. And why did he tender 30 evidences? He tendered 30 evidences just because Tinubu and INEC lawyer were slowing down the occasion, because whenever Peter Obi lawyer made any point, they will always stand up. Tinubu lawyer and INEC lawyer will always stand up to object the motion. Objection, my lord, flying up and down in court, and that makes the ruling to be very slow. That makes the process to be very slow for Peter Obi lawyer. They would have been able to tender more than 13 evidences, but due to the shenanigans of INEC and Tinubu lawyer in court, they were able to tender 13. But Peter Obi still came out and make a press conference for all obedience. He said they should not bother themselves, that they should be rest assured that their mandate will really come. So Tinubu is in trouble at the moment because what Peter Obi lawyer dug out, it wasn't expected. Tinubu is not expecting it at the very moment, because this is a tragic moment where Nigerians have turned their back against Bola Ahmed Tinubu. Even the people that voted for him, you know, it's normally known that a lot of people did not vote for him, but INEC gave the mandate to Tinubu. A lot of people did not vote for him, and the people that still voted for him, many of them have made a U-turn due to the economic crisis and the hardship that I have bestowed upon the country. You know, the poor are suffering, and yet the people in the House of Senate, the business sharing money, Akpabio and all of that, in the light of other senators, they were sharing money, not feeling the pain of the poor. People cannot even afford to eat 3 square meals again. People are not even seeing 2 square meals, talk less of even 1 square meal. A lot of people are not saying 1 square meal to eat in the regime of Tinubu. Is more worse than Buhari government of 8 years. Tinubu government is not even up to 7 months, but people are already dying in hardship. They are already dying with hunger and all of that. So people that voted for him have made their U-turn. So everybody are looking out for Obi now. Even the people that did not vote for Obi, they are looking out for Obi to reclaim his mandate. And the lawyer of Obi, they are in action now. They are making the mandate to come in favor of Peter Obi due to what they are analyzing in court. So then I would like guys to stay connected to the end of this video. You can share it to different social media platforms. Let it go viral, and if you can share it, like it, give it a thumb up so that it will be recommended for us. I'm going to leave you now to watch the ruling live. With stay connected. I'm coming back again.
My lord, my names are Omar Ilya Damagung, International Chairman PDP, for the second petitioner.
May it please my lords, this is May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Dr. Abdullahi Umar Ganduje, National Chairman, APC, third respondent.
One petitioner is represented before the court, as well as the first and third respondent, my lord. Other parties are absent.
LAJUPOG, make you listen to what they go. What they go, Agbede, what they go for Nigeria. Sit down, barakata. Sit down, barakata. Sit down, make you hear the gist, barakata. Oh no, miss, I see the hot from my body.
With profound respect to my noble lords, I am Chief Chris Uche. I appear for the petitioners, and with me are my learned brothers Silk, namely Iyitayo Jegede SN, Professor Mike Ozekome SN, Nella Andem Ewa Rabana SN. And my lords, permit me with respect to replace absent number 5 with my brother Silk Joe Abraham SN. Then number 6, Professor Maxwell M. Gidado SN.
Yes.
7, Chief Godi Uche SN.
Yes.
8, AK Ajibade SN. And with us, my lords, our learned friends, Silas Joseph Ono Esquire, and Jude A. Daniel Esquire. Together, my lords, we appear for the petitioners. We are grateful, sirs.
May it please my lords, I am Sir Stephen Adehi. I appear with my learned friends, Senior Counsel, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleman Olawale Ibrahim, SAN, and my appearing with us are learned colleagues, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imoisi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We appear for the first respondent. Thank you. May it please my lords. Okay.
With profound humility to my noble lords, my name is A. Malik. I appear, my lord, for the second respondent. Learned brothers of the Silk, Babatunde Ogala, SAN, Dr. Remi Olatubora, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. And we have our other colleagues, Emmanuel Uwadoka, Esquire, Inka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and lastly but not the least, Taiwo Lakano, Esquire. Together, my lord, we appear for the second respondent. Pray for my lord.
My lords, for the third respondent, I am Charles Uwensi Edosawa.
Yes.
My lords, my learned friends, Chief Adeni Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologunrisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abdul Muhammad Rafindadi, Esquire, SAN, and my learned friends of the Outer Basa, Mr. Omosoya Popola, Mr. Olarewaju Akinshola, Mr. Bolaji Oyun, and Miss Uwaila Muhammad Ibrahim. They're all with me, sirs, for the third respondent. Most grateful, sirs.
Pastor with the back, where politician with the do pass, corrupt leader. I see the hot from my body, I say make I yarn you. Religious gossip today for body, for you. Pastor with the line on top, pastor for LAJUPOG watch TV. Pastor with the back, where politician with the do pass, corrupt leader. I see the hot from my body, I say make I yarn you. Religious gossip today for body, for you. Pastor with the line on top, pastor for LAJUPOG watch TV. Pastor with the back, where politician with the do pass, corrupt leader. I see the hot from my body, I say make I yarn you. Religious gossip today for body, for you. Pastor with the line on top, pastor for LAJUPOG watch TV. Pastor with the back, where politician with the do pass, corrupt leader. I see the hot from my body, I say make I yarn you.
Well, I'll deliver the judgments, but know that we all know the rules concerning consolidated matters. Each of the petitions, so consolidated, will maintain their individual identities, so we shall treat them as such. We shall begin with petition number 4.
Religious gossip today for body, for you. Pastor with the line on top, pastor for LAJUPOG watch TV. Pastor with the back, where politician with the do pass, corrupt leader. I see the hot from my body, I say make I yarn you. Religious gossip today for body, for you. Pastor with the line on top, pastor for LAJUPOG watch.
Well, we all remember that during the pre-hearing session, several motions were filed. So we shall begin with the consideration of these applications before we proceed to the main petition. So in this petition, that's petition number 3 and number 4, sorry, the petitioner here is
for body. Pastor where they lie on top, pastor. For LAJUPOG Watch TV.
Allied People's Movement participated in the presidential election conducted by the first respondent on the 25th of February 2023 by sponsoring a candidate, that's Osayi, Princess Chichi, agreed by the declaration and returned at the election, has via its petition filed on the 20th day of March 2023, read this court at paragraph 31 of the petition to grant it the following reliefs. 1. That it may be determined that A, the third respondent was not qualified to contest as the presidential candidate of the second respondent as at 25th day of February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 142, Sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. B, a declaration that the return of the third respondent by the first respondent as the president-elect of the Federal Republic of Nigeria is null, void, and of no legal effect whatsoever. The third respondent having violated the provisions of Section 142, Sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the fourth respondent having violated the provision of Section 35 of the Electoral Act 2022. C. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. E. The declaration and return of third respondent by the first respondent on 1st March 2023 as the president-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that, having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of the presidential election held on 25th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 25th February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the grant of prayer for above, an order nullifying and or setting aside the return of declaration of third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. And finally, upon the grant of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 25th February 2023, pursuant to Section 136 sub 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition on the 16th of April 2023. The petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the competence of the petition. These motions were duly heard during the pre-hearing session and ruling reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein he sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 15 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall deem fit to make in the circumstance. We were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling. I need not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by written address in opposition to the application. The arguments of counsel in respect of that application have been considered. It is here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the pre-hearing session in this petition. It should be noted that this court is sitting as the Court of Appeal, not as a tribunal. So, an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5. Paragraph 18, 19, 20, 21, 22, 23, and 24 of Part D of the petitioner's reply and or the entire petition reply to the second respondent's reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statements on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this judgment, the same thing with the submissions of counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21 of the petition reply under the heading Petition Reply to the third respondent's reply to the motion filed on 20th April 2023 to the applicant's reply to the petition, and for such further orders as this Honorable Court may deem fit to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition struck out. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, that some of the averments are rehash or repetition of the averments in the petition file. That those averments in the petition replies offend paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issues of fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. And B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act are clear, unequivocal, and unambiguous. It does not, therefore, require any text or to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the reply. Is to raise answers to the defense or any fact which must be specifically pleaded and which have the effect of destroying the respondent's defense or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply while the respondent to the petition has in his reply raised new issues of fact in the petition, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP that petitions apply. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingyadi and Wamato citations of supply. With the state of the law as stated above at the back of my mind, I have endeavored to scrutinize the pleadings in the respondent's respective replies to the petition. These are the specific paragraphs of the petitioner replies complaint of. I start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 of petitioner reply. I have carefully studied those paragraphs of petitioner reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of petitioner reply to the first respondent reply are competent as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent, as they are either rehash of facts pleaded in the petition or they introduce and or add new facts to the petition. Being incompetent, they are hereby struck out. The complaint of the second respondent is against paragraphs 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4 and 5, sorry, 18, 19, 20, 21, 23, 24, and 25 part B of the petition reply to the second respondent's reply to the petition. I have carefully considered both paragraphs in the light of paragraph 16(1)(a) and B of the first schedule to the Electoral Act 2022. It is settled law that where a respondent raises in his reply to the petition fresh or new issues, it will be necessary for the petitioner to file a reply to the respondent's reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses. He may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer to those new issues raised by the respondent will be deemed that the petitioner has conceded to such fresh or new issues. The cases of Idris and ANPP, Bingadi and Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petition reply to the respondent reply in proof of the paragraph struck out are accordingly struck out. In my view, paragraphs 1, 2, the paragraph listed of the petition reply to second respondent reply to the petition are either rehash of paragraphs in the petition or introduced or added new facts to the petition. They are incompetent and accordingly struck out. Also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 to 20 of the petition reply to third and fourth respondent reply to the petition are rehash of the vermins in the petition. They are, in my view, incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May 2023, seeking the following relief. 1. An order of this Honorable Court striking out the petition for being incompetent and an abuse of court process. The grounds of filing the motion have been produced. The motion is supported by 6 paragraphs, affidavit deposed to by 1 Chief Nwadike, a litigation secretary in the law firm of Dikko and Mahmoud, solicitors to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the 14th of May 2023, consisting of 7 paragraphs, deposed by 1 Carlo Kenneth Okorie, litigation secretary in the law firm of Mrs. O.M. Atoyo B.S.N. and Partners. A written address was also filed along with the counter affidavit. I consider the arguments of counsel on this motion. The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this Honorable Court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this Honorable Court to adjudicate thereon. The grounds for the application have been listed. In this motion, several grounds were raised.
Pastor with the back, politics are with the do pass, corrupt leader. I see the hot for my body, I say make I am religious, cause plenty day for body, day for you. Pastor with the line on top, pastor, for LAJUPOG watch TV. Pastor with the back, politics are with the do pass, corrupt leader. I see the hot for my body, I say make I am religious, cause plenty day for body, day for you. Pastor with the line on top, pastor, for LAJUPOG watch TV.
Now it is apparent that the sole ground of this petition is stance on the qualification of the second respondent. The issue of qualification The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134, subsection 1A of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of a candidate to contest an election for the office of President are stipulated in sections 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inherent in section 131, the disqualifications are ingrained in section 137, subsection 1A to J of the Constitution, supra. It is apparent, therefore, that the issue of qualification of a candidate to contest an election could be a ground in an election petition, though it may also be ground a pre-election matter, where such issue of qualification or disqualification of a candidate arises from the primary election of the party by virtue of section 285, subsection 14 of the Constitution. Where the issue of qualification of disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to section 285, subsection 11 and 14 of the Constitution. It should be noted that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been reproduced. The second issue, arm of that issue is captured in paragraph 22, 23, 24, and 25, and 26 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification disqualification, non-qualification with third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is a certain law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in sections 131 or 137 of the Constitution. That is why section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for elections, except as prescribed under section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that the conditions of qualification or disqualification are prescribed by, under sections 131 and 137 in case of person contesting for office of president. That means that where it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in section 134, subsection 1A of the Electoral Act 2022, it is sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and INEC, Kaki and PDP, Ucha and Unwe, and Captain Idris, Ichala Wada and others, versus Yahya Bello and others, all citations supplied. That's why election has been conducted and result declared. Such election cannot be questioned on grounds of qualification under sections 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by section 134, subsection 3 of the Electoral Act, where it is stipulated that With respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of section 65, 106, 137, or 177 of the Constitution, and he is not, as may be applicable in breach of section 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are section 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondents is hinged on double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly a requirement of the Constitution. That it was held in the case of Al-Hassan and another versus Ishaku and others, citation supplied a court by virtue of the provisions of section 138 sub 1A of the Electoral Act. The tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party. Close of court. It is apparent, therefore, that issues of nomination or sponsorship of...
Thank you for staying connected, my great and wonderful viewers. I would like you guys, as you're watching the live judgment in the tribunal, I would like you guys to drop your opinion at the comment section of this video. If Tinubu should win this ruling, what do you think will be the hope of Nigerians? If truly Tinubu will win this ruling and all of that, you know, it's normally news that they bribe judges in the tribunal, and one of the judges came out, a woman among the 5 judges. The woman among them came out and he shouted out to the general public. He said they should not bring their useless bribe to her table, that she's contented with what her family have and she's okay with what God have given to them, and all of that. That shows that there's bribe ongoing in the tribunal. So they're bribing the judges, and many of the judges are okay with the bribe. They're looking out for the person with the highest bid and all of that. So what do you think? Do you really think the tribunal are going to make the justice as it's supposed to be, or they're going to provide justice, or do you think they are not going to provide justice? Drop a opinion in the comment section of this video. What will be the hope of Nigerians if Tinubu should eventually win in the tribunal? You know, the tribunal is not only the option now. We still have the Supreme Court. You know, if the parties candidate they are not okay with the tribunal judgment, they still have their way to the Supreme Court. They can still chase their mandate to the Supreme Court. You know, if Peter Abi did not win in the tribunal and all of that, there's still a chance in the tribunal where the Chief Judge of Nigeria will judge the case, and that will be the end of everything.
Him as such associate is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional qualifications or disqualifications for a candidate contesting for the office of President of Nigeria. Furthermore, Section 142 of the 1919 Constitution, read along with Section 141 of the said Constitution, create the office of President and Vice President. Section 142(1) is a specific provision donating power to the President to nominate a person as his associate to occupy the office of the President. That's why subsection 2 of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of President also applies to the holder of the office of Vice President. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of Vice President so as to enlarge the scope of qualifications or disqualifications applicable to the seat of President. There cannot therefore be a disqualifying factor of a candidate for the office of President outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. See the cases of IG, ABIA and AG Federation, also PDP and INEC Supra. As a fallout to my findings above, I hold the firm view that the issue of nomination or sponsorship of the first respondent, being a pre-election matter, ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, the course of action being a pre-election matter is statute barred by virtue of Section 285, Sub 9 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondents on 7 May 2023 and 12 May 2023 respectively have no merit. Accordingly, I find that the petition is have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent. By a motion on notice filed on the 8th of May 2023, the second respondent, the applicant, sought the following relief. An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2. An order of this Honorable Tribunal striking out grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3. An order of the Honorable Tribunal striking out paragraph 17, 18, 19, 20 to the 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4. An order of this tribunal striking out reliefs 1 to it will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance and it is accordingly discountenanced. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner's respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABJ/CS/1215/2022 between Allied People's Movement and INEC and 12 others on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was however deposed in paragraph 3M of the counter affidavit filed by the petitioner in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the court appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process mala fide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC-ABJ/CS-1275/2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also pronounced. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in Appeal number CA/ABJ/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party again in the same or subsequent proceeding except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings with the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amudu, OSPM Limited versus Nibel Company Nigeria Limited, which is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates, I quote, an election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May 2023, the fifth respondent, Das Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders at this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. Have also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, Subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis and is procedure strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor perform any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election, and even no relief was claimed against the said fifth respondent, and indeed he had nothing to gain or lose in the petition aforesaid. Close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act.
Go.
The following are the breakdown of the proceedings from the court so far. The court has struck out some paragraphs 4, 5, 14, 15, and many others of the petitioner's reply to the respondents have been struck out for introducing new facts. The court is extending to several applications which were made before the court. The one above are applications made by the respondent to strike out some paragraphs of the petitioner's reply, not the petition proper. The court has ruled that 1. Qualifications of a candidate can only be contested under Section 131 and 137 of the Constitution. 2. Tinubu and Shettima cannot be disqualified on the basis of double/multiple nomination or even sponsorship. 3. P2B's attempt to use 142(1) of the Constitution as a basis will not be upheld by the court. 4. The issue of double/multiple nomination should have been ventilated in the Federal High Court. The court holds that the application have no merit and is struck out for being incompetent. The court have struck out 2 grounds of objection by the respondents against the petition. They had argued that the petition was filed out of the time and is packed in merit. They also argued that since the petitioners had instituted an action in the High Court, which was thrown by the doctrine of estoppel, the petition should be thrown out. The court held that it was a different suit and the former was a pre-selection matter while this is post-election. The courts have held that the petitioners have no local standing to question issues of nomination as it is a pre-election matter. It further held that anybody who is not a member of a political party must look numb and be an onlooker as he does not have local standing. The courts have struck out the grounds for being incompetent as it is purely a pre-election matter and internal party affairs. The courts have discountenanced the motion of the petitioners for not joining other parties, PDP. The court held that a candidate or political party can institute an action. Hence, it is okay if they decide to include that party or not. He further held that joining them is just to make them bound by the judgments. The court now proceeds to the main petition. Stay tuned, stay glued. As it stands, the APM have no case anymore as their issue for disqualification was solely tied to provisions, the Electoral Act, and not Section 137 of the 1999 Constitution. Now let's go back to the life in court.
Including the issues raised by the petitioner.
For my body, I say make I yarn you. Religious gossip today for body. Pastor where they lie on top, pastor. For LAJUPOG watch TV. Pastor where they back, where. Politicians where they do pass. Say for leader. I see the hot for my body, I say make I yarn you. Religious gossip today for body. Pastor where they lie on top, pastor. For LAJUPOG watch TV. Pastor where they back, where. Politicians where they do pass.
Now it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 25th February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent who have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 25th February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraph 16(1) and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you'll see there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, so clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)(a) that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for determination of the petition. Which paragraphs have been reproduced in this judgment? In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. Second respondent also filed a second respondent reply to the petition, and also made their own averments in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A. he is a citizen of Nigeria by birth, B. he has attained the age of 40 years, C. he is a member of a political party and is sponsored by that political party, and D. he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected the office of vice president if the candidate is for election to the office of president who nominated him as such an associate is duly elected as president in accordance with the provisions aforesaid.
And if Peter Obi should eventually win the tribunal judgment at the moment, what do you think will still even be the hope of Nigeria? Do you really think all the abilities that people are looking out in Peter Obi, do you really think he's going to dispense everything? Do you really think Nigeria will come back to their normal state? What do you think? or if Tinubu should win the tribunal judgment and all of that, do you think coup is not going to take over Nigeria? They have taken over Mali, Burkina Faso, Guinea, Gabon, Sudan, and other big countries like Nigeria and all of that, because coup alone is reigning in Africa at the moment. If Tinubu should win in the tribunal, do you think there won't be a revolution? Do you think there will be a revolution? I would like you guys, as I'm saying, you should drop in your opinion in the comment section of the video. This is an interactive session where we speak our mind due to our freedom of speech and expression, and that's our fundamental human right. Drop your opinion in the comment section of this video. Do you really think coup will not take over Nigeria if Tinubu should eventually win? But at the moment, Peter Obi winning is in 70% and Tinubu winning is in 30%. Atiku is not even having up to 10% chance at the moment due to what is going on in the tribunal right now. I endeavor you guys to drop your opinion in the comment section of this video, as I'm going on there to get another trend on it for you. Stay connected on this video, watch it till the end, and see what the rolling is all about. See who will win the rolling and all of that. I'm going on there to get another trend for you. Ensure you follow me on all my social media handles on Facebook at LAJUPOG TV and LAJUPOG Entertainment, and on Instagram at LAJUPOG. Guess what, guys? See you in my next video. Bye.